history for the declaration of trespass on the rights, privileges, and immunities of the sovereign souls of Texas by the Republic for the United States, and further, the respondents, having failed to answer the subject matter of the declaration of trespass, ask for more time or request a proper formal hearing in and before the de jure grand jury of the people of Texas within 10 days, time later allowed, and no extension having been requested nor granted, the default judgment nihil defeat of respondents is hereby entered and ordered against all named and constructively noticed respondents as to each and every fact, assertion, and statement set forth in the declaration of trespass. Therefore, this default judgment, nihil defeat and order, hereby adjudicated in favor of sovereign souls of Texas and against the Republic for the United States and each and every one of the respondents herein named, shall serve as a conclusive finding of fact with respect to, inter alia, the following: that the respondents lack the authority of law under the fundamental law of the land, the primary fact and evidence being but not limited to the failure to promulgate the said declaration of sovereign intent, and that the Republic for the United States of America has no authority of law to impose or attempt to impose, both now, hereafter, and in perpetuity, on any of the several 50 Republic states of the Union, the Declaration of Sovereign Intent produced at Windwalker Ranch on November 14, 2010. And that the Republic for the United States of America is in want of primary administrative and territorial jurisdiction for prosecution and otherwise, both in rem and in personam, to impose or attempt to impose, both now, hereafter, and in perpetuity against sovereign souls of the dry land or their property, any legislative, executive, or judicial statutory code liability in the nature of civil or criminal sanctions. Notice is hereby given to each and every one of the respondents' claimants that this notice of default judgment and order is final and not subject to review, being subject to the Seventh Amendment of the Bill of Rights, circa 1791, to the Constitution for the United States, circa 1789. Notice is hereby further given to the Republic for the United States of America and each and every state republic of the several states of the Union that the Declaration of Sovereign Intent is hereby declared null and void in Texas because of failure to present evidence of the authority of law under the fundamental law of the land and evidence of the conformity to the enactment provisions of the Constitution for the United States of America and evidence of promulgation. Now, why did they send that notice of default? The answers to that are in a couple more documents from Texas. After that was issued, let's let that train go by for a second.
Terry?
Yeah, hold on a sec.
Terry, was that you or the dogs?
No, that's the dogs next door.
Okay.
Oh no. Yes,
they have to chime in with that train whistle there.
Oh yes.
And
I'm
probably
familiar with it.
You probably heard my 3-year-old granddaughter. She does a really mean Labrador. She scared the people in Walmart one night really well with it. Okay. After that default judgment was issued by the Texas grand jury, remember, that was not a letter. That was a default judgment issued by the Texas grand jury, the people of Texas, not the elected officials. A press release came out after that. And it says, many of our Texas people and others from around the nation are asking what caused the violent reaction of President Turner concerning Texas on Thursday night's Republic Roundtable call. First, let me say that the documents Turner is referring to are available on our Texas website. The document in question is a default judgment issued by the Texas grand jury. Also note that this is a default judgment issued by we the people of Texas through their court, the Texas grand jury. This is not a document by any of the Texas public officials. Back to what happened in Texas. Remember that was a complaint filed with the Texas grand jury, who are the people of Texas. It was not a letter from elected officials. And in the press release that came out afterwards, there were the following issues relative to the said declaration that are not all the concerns, but they were the main concerns of the people. And the declaration we're talking about is that secret document out of Utah. Now remember, the people who went to Utah, they were trusting souls, but they signed 5 blank pieces of paper. No headers, no footers, no numbers, no knowledge at all of what those signatures would actually be attached to. They just trusted that those signatures would eventually be attached to this secret document that was written, known as the Declaration of Sovereign Intent in Utah. Now, these were the concerns of the people in Texas. It appears from several sources that a claim was made by national government on the land of Texas, as well as on other states in the Declaration of Sovereign Intent, and I know that. The land area over which the national government can exercise their authority is but a 10-square-mile area of the District of Columbia. Remember that. That is from Article 1, Section 8 of the National Constitution. Number 2, it appears that the Declaration of Sovereign Intent was drafted in part by parties present at the Utah session to correct what they considered to be errors in the declarations made by the de jure grand juries of the 50 state republics in March of 2010. Congress does not have the authority to do anything to a declaration of the sovereign people of any of the 50 state republics. If they do, then the people are not sovereign. Also read the 7th Amendment. Congress changed the law forms in Utah in the Declaration. The laws applicable within the United States were established by we the people in the Constitution. Congress cannot change what the people ordained. If they could, then Sharia law could be adopted by the Congress in the future. Any change in the bodies of law will be in effect in the United States has to be done by we the people. And lastly, the Declaration of Sovereign Intent has never been published, and a law is not a law until it is published. How can the state or the people be expected to comply with a law which is secret? That is why laws have to be made public before they are effective. After that press release was released, another document came out of Texas, and this was an affidavit of truth. This was written by we elected Texas officials, all being private citizens first class, do hereby affirm, declare, and give notice that. I will skip over the preamble and their intent of being a sovereign people, etc., and I will get down to the meat of the cause for their affidavit. We hereby affirm the following statements in response to the misrepresentations by President Turner on the Republic Roundtable call and certain national public officials, stating they have removed the Texas elective public officials or by our actions have removed ourselves. 1. Neither the office of the President of the United States nor the Congress of the United States have the constitutional authority to remove any state official from office. I would like to point out here, folks, this is not the first, this is not the second, the third, the fourth, the fifth, the sixth, or seventh time that they have done exactly that.
I second that.
You should know. 2, the oaths of Texas elected public officials are to the people of Texas. Therefore, the only authority for the removal from office of any state official is through the power of the people. The sovereign people of Texas are the only parties to the compact who have the jurisdiction to remove their public officials from office. Number 3, any attempt by national public officials to remove any Texas elected public official from office is a common law trespass and damage upon the people, which clearly becomes a color of law crime for which the usurper becomes personally liable. Number 4, further, the Texas elected public officials did not send the letter of interest referred to by President Turner. The document President Turner was referring to was a default judgment sent by we the people of Texas, sitting as the people's de jure grand jury. Number 5, the Texas grand jury is the same as the de jure grand jury who acted in concert with the other 49 de jure grand juries that re-inhabited their respective state republics on March 29, 2010. The authority by which they were convened was on no other authority than their own as set forth in the common law and as memorialized in the Magna Carta. The sovereign people of Texas set forth the re-inhabitation course of action for which the Texas elected public officials are required to follow. Number 6, it is this same de jure grand jury that was honored on March 29, 2010, that certain national public officials are choosing to ignore and assumingly claim they have no obligation that requires them to answer. Therefore, the Texas elected public officials state unequivocally that they did not individually nor corporately communicate, formally or informally, any such removal of Texas from the Union, nor did they remove themselves by their actions as elected public officials, since they were not the parties who sent the document referred to by President Turner. Now, after hearing, in the words of the people of Texas themselves, I'm sure you did not hear anywhere in there that they refused to abide by the law, that they refused to look at the Declaration of Sovereign Intent. As a matter of fact, that's what caused this whole thing. When the people of Texas became concerned that Turner intended to use their land and their natural resources as collateral for a loan from some shadow organization for funding, which would fund him and his national thugs to dole money out to the states the way our corporation is doing to us now, upside down from what our republic truly is. They demanded to see that Declaration of Sovereign Intent. They gave National 45 days to comply, to bring that document for their perusal. They did not refuse to go along with the loan. They did not refuse to abide by any law. They simply demanded what they have a right to demand, that any law, which is professed to be a law, be transparent, be presented to them, and they be cognizant of the terms of any loan which would collateralize all the land and natural resources of this nation. I put it to you, ladies and gentlemen, that the people of Texas did the only responsible and free-thinking action that we could expect them to do, that you and me as a free person on this land would be expected to do. They asked questions and they demanded answers. Now, I'm sure you noticed how Turner kept claiming that the Congress makes laws over the people. Do you know your history